consideration of the report from the Appellate Committee in the cause the Queen against Metropolitan Stipendiary Magistrates, the Secretary of State for the Home Department, and the Government of Spain, ex parte Augusto Pinochet Ugarte.
My Lords, I beg to move that the report of the Appellate Committee be now considered. The question is that the report of the Appellate Committee be now considered. As many as are of that opinion will say content, the contrary not content, the content have it. My Lords, for the reasons set out in the speech which I have prepared and which is available in print, I would hold that the respondent as a former head of state is immune from arrest in respect of the matters alleged in the warrant of the 22nd of October 1998, and I would dismiss the appeal.
My Lords, in my opinion, the state of Chile is entitled to claim immunity on behalf of Senator Pinochet under the terms of the State Immunity Act of 1978 and at common law. I would therefore dismiss the appeal.
My Lords, for the reasons set out in a speech which I have prepared in draft and copies of which are available in print, I would reverse the decision of the Divisional Court, allow this appeal, and hold that the respondent, Senator Pinochet, is not immune from the criminal process of this country, of which extradition forms part.
My Lords, for the reasons contained in my speech, copies of which are available to the parties, I would allow the appeal. The effect of my speech is that in a correct interpretation of the law, General Pinochet has no immunity whatever.
My Lords, I've had the advantage of reading in draft the speeches of my noble and learned friends, Lord Nichols of Birkenhead and Lord Steyn. I agree with them that Senator Pinochet does not have immunity from prosecution, and I too would therefore allow the appeal.
My Lords, I beg to move that the report of the Appellate Committee be agreed to. The question is that the report of the Appellate Committee be agreed to. As many as are of that opinion will say content, the contrary not content, the contents have it. My Lords, the question is that the order of the Divisional Court of the 28th of October 1998 relating to the decision of Mr. Evans, sitting at Bow Street Magistrates Court on the 16th of October 1998, and to issue a provisional warrant for the arrest of the respondent be affirmed, save as to costs. That the order of the Divisional Court of the 28th of October 1998 relating to the decision of Mr. Bartle, sitting in the same court on the 22nd of October 1998, and to issue a further provisional warrant for the arrest of the respondent be set aside, and that the said decision of Mr. Bartle be restored, and that the warrant be not quashed, and that the respondent do pay to the appellants their costs in the Divisional Court and in this House. As many as are of that opinion will say content, the contrary not content, the contents have it.
Lords, I beg to move that the House do now adjourn during pleasure.
My Lords, the question is that the House do now adjourn during pleasure. As many as are of that opinion will say content, the contrary not content, the contents have it.